Ms. Gaines? That's who I have on this one.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Kyle.
All right, what are we doing on this?
Your Honor, we have made all necessary attempts to ensure that our victim is present today. However, she's not in attendance. I do have a forfeiture by wrongdoing motion that I have prepared and ready to file today as a result of her not being in attendance today. I have it prepared and I can hand it to your staff immediately, as well as send it electronically. I do also want to note for the record that we had previously had a hearing to have the defendant's phone privileges revoked on the 28th.
Right out of the gate, this hearing already feels messy, and that's usually a warning sign in cases involving witness concerns and jail communication violations. The prosecution is not walking into this courtroom casually. Here, they're arriving with a forfeiture by wrongdoing motion already prepared before the hearing even fully gets rolling. That tells you they believe something serious may have happened behind the scenes involving the victim's availability or willingness to appear. Then things get even more tense when the prosecutor starts laying out the issue with the defendant's phone privileges not being properly revoked despite prior court discussion. That is a massive procedural problem because once a defendant continues gaining access to communication after restrictions were supposed to be in place, every single call suddenly becomes important. And listen carefully to the prosecution's concern here. They are not accusing blindly. They're saying they have not reviewed every call yet, which actually makes this more dangerous because it means there may still be unknown information sitting inside those recordings. The courtroom atmosphere instantly changes from routine scheduling to potential witness interference concerns, and Judge Simpson is now being forced to balance due process with growing fears about continued contact attempts.
That was then carried over to the court. On the 28th, we adjourned it out and didn't argue that motion, but you revoked his phone privileges pending the hearing that was going to continue over until the 4th. On the 4th, there was no objection to his phone privileges being revoked, and so they shouldn't have been revoked at that time. However, that order was never provided to the jail by the court, and since the 4th, the defendant has made in total 129 calls to family and friends, including his grandmother, who was the one who patched in the victim previously, which was the basis for that motion, which I filed back on the 28th. I have, because of the number of calls, I have not had an opportunity to listen to them all, or frankly, any of them, but I am significantly concerned that what I did listen to back from the 4th was a call between the defendant and his grandmother in which he indicated he knew he was not supposed to have his phone privileges, but that he was going to continue calling because he did have his phone privileges. I'm concerned, and I do, like I said, have the forfeiture by wrongdoing motion. I will say clearly for the record, I did not see any calls to the victim's phone number, so I believe that was successfully blocked by the jail, but because I haven't had an opportunity to listen to the calls, I don't know if his previous methodology of having her patched in was used to continue to contact and edit of any kind.
Got it. Ms. Gaines?
Your Honor, this is the first I've heard of this. Last information I had from Ms. Barroso was that she would be requesting an adjournment so that she could file the forfeiture motion.
This is where the defense immediately tries to slow the momentum down. And honestly, strategically, they almost have to. Notice the defense attorney stressing that this is the first time hearing some of this information. That matters because when prosecutors introduce allegations involving possible witness manipulation, jail calls, or indirect communication, defense counsel wants the record to reflect they were not given advance notice to properly respond. But at the same time, look at the position the defendant is now stuck in. The prosecution is basically painting a picture that even after phone restrictions were discussed, the calls kept happening anyway, more than 100 calls according to the prosecutor. That number alone creates a psychological impact inside the courtroom even before anyone listens to every recording. And then comes the detail that really raises eyebrows. The defendant allegedly telling his grandmother he knew he was not supposed to have phone privileges but continued calling because the jail still allowed access. That is the kind of statement judges remember. Even if there's an administrative breakdown somewhere in the process, a defendant openly acknowledging awareness of restrictions can become extremely damaging when credibility and future bond arguments come into play.
That's the last information I have. I have not had an opportunity to discuss this with my client. He has indicated that there has been no contact with the complainant. And, certainly that was the primary intention of the order. And he, as indicated previously with Mr. Banas, has no objection to his phone privileges being revoked. Is that correct, sir?
So I'm going to make it very clear. Defendant's phone privileges are hereby revoked. I will set the hearing on the motion for forfeiture by wrongdoing for May 9th, 2024 at 3 p.m. I will adjourn then the defendant's preliminary examination to my following date of May 21st, 2024, 9 a.m. before me. And we'll continue. Thank you.
Your Honor, we did want to
Go ahead.
address bond, if we may briefly.
Go ahead.
Yeah. Your Honor, Mr. Kyle does have a union job that at this time is his understanding continues to wait for him. He also has his own apartment, his own home that he hopes to be able to go back to the job and to maintain that home. He also states, it's also my understanding that he is a parent. We are asking that the court reduce his bond. It's my understanding that it's currently $100,000, 10%. We're asking for it to be a $10,000 cash or surety bond.
This bond argument shifts the energy in the courtroom fast because now the defense is trying to humanize the defendant before the prosecution fully controls the narrative. The attorney brings up employment, housing stability, parenthood, and future responsibilities, all classic factors used to argue that somebody has community ties and reasons to comply with court orders. But here's the problem. Those arguments only work effectively if the prosecution cannot immediately counter them with safety concerns or witness intimidation allegations, and that is exactly what happens seconds later. The prosecution comes back aggressively with allegations involving strangulation, interference with a 911 call, and witness intimidation tied to jail communications. Once strangulation allegations enter a bond discussion, judges tend to become extremely cautious because courts often view those accusations as indicators of escalating violence risk. Then prosecutors connect the grandmother back into the story again, reinforcing the idea that communication channels may still exist despite restrictions. You can almost feel the courtroom moving away from the defense's stable working parent narrative and back toward potential danger and manipulation territory. That is why Judge Simpson's denial lands hard here. The court is signaling that, at least for now, public safety and witness concerns outweigh arguments about work, housing, or financial hardship.
Your Honor, just so the record is clear, this is not the only case holding him. He does have a witness intimidation case resulting from his contact with the victim here that is up for PCC on Thursday. In that case, there is an additional $100,000, 10%. We did request $250,000 cash or surety. In that case, here we requested $100,000 cash or surety. The reason for that is because in this particular case, the defendant woke up his victim, who was the mother of his child, by strangling her and threw her to the ground. And then when she tried to call 911, he took her phone, called his grandmother, the person he's been contacting on the jail calls, and his grandmother told the victim not to call 911, which is the basis for count 2 of interfering with electronic communications. At this time, we are hoping that the witness intimidation that's up on Thursday will be able to catch up with the PE in this case, and we can handle it all at once. But I would object to any reduction in bond here.
Motion for bond reduction is denied. Bond will continue.
Court calls the case People versus Jason Stevens.
Assistant Prosecutor.
Good afternoon, Your Honor. Olga Yermolenko, on behalf of Mrs. Stevens, who's present.
Your name, sir?
Jason Stevens.
On behalf of probation, Your Honor, the victim is in this case is present and would like to address the court.
All right, you two can step back and. Hello,
Hello, Judge.
what's your name?
My name is Kashmir Morley.
All right, very good. What would you like to tell the court?
When I was 24, just barely out of college, I applied for a job as a note taker for an exhibit design company in Ann Arbor. I met Jason for the first time as an interviewer. We talked about career goals and how I was really interested in a graphic design role, though I was willing to take on other hats to get my foot in the door somewhere creative.
Now the courtroom takes a dramatic, emotional turn, because this is no longer just lawyers arguing procedure. This is the alleged victim personally addressing the court. And immediately, her testimony starts building a timeline of trust, mentorship, and power imbalance. Pay attention to how carefully she explains the professional relationship first, before discussing anything personal. That structure matters because she is trying to show the court how a workplace connection slowly evolved into something she now views as manipulative and abusive. She describes being young, newly entering a creative industry, ambitious, and eager to grow professionally, while the defendant already held authority, experience, and control inside the company environment. That age and power gap becomes a recurring theme throughout her statement. Also, notice how she frames the early friendship and mentorship as something she later reconsidered through a completely different lens. In emotional courtroom moments like this, judges are not only listening for allegations, they are evaluating consistency, emotional presentation, chronology, and credibility. And the deeper this statement goes, the more it shifts from a simple employment dispute into allegations involving grooming, coercion, dependency, and abuse of authority inside a workplace relationship.
Months later, he would hire me as just that, a graphic design contractor for his company. For 2 years, I did small projects for him, working my way up to be his design assistant. I was 26 at that time. For those 2 years, we forged what I thought was not only a strong creative partnership, but a friendship. I look back over that time now and see that those were 2 crucial years that he built my trust and my friendship as a form of predatory grooming. What did the title design assistant entail? Doing everything for this man, and I mean that quite literally. Me out to lunch one day on a long solo work trip back from Kentucky, where he and I would be sitting alone, to tell me that he and his wife were in an open relationship, something I would later come to find was a lie, to get in my pants. I remember feeling uncomfortable about him sharing this with me, his female understudy, who at the time was in an almost decade-long romantic relationship of my own. I chalked his transparency up to our close friendship and didn't put much thought into it again until he started bringing this up quite frequently. If you ever want to have some fun, let me know, he told me one day. I think you and I would be amazing together. I was, again, 26, and my long high school sweetheart relationship was falling apart, though no one knew, including Jason. Jason was 47 at this time and married with a child. Eventually, upon his probing, I would share with him that I was fresh out of leaving a long-term significant other. At this point, I was only 2 years out of college. My career was just starting to form. I was in a position of fragility in my life, and he knew that. I told him I didn't think it was a good idea. I told him that crossing that boundary would ruin our work relationship. He said to me words that would come back to haunt me. In September of 2023, you'll always have your job no matter what. The what became years and years of sexual abuse, emotional abuse, physical abuse, abuse of power. The what became me telling him no and it happening anyway. I noticed that Jason began taking away work tasks from me whenever I wouldn't sleep with him. Every day I came into the office to do my job, instead became a game of mental gymnastics for me. Is he going to tell me I'm fired again today for no reason at all? Will he tell me I'm no longer working on this project for no reason that he can give me? The abuse was constant. If it wasn't emotional, it was physical.
At this point, the victim's statement becomes much darker because she is no longer describing isolated incidents. She is describing what she believes was a long-term system of control. Listen to the pattern she lays out: emotional pressure, professional retaliation, fear of losing work opportunities, constant instability, and physical abuse allegations layered on top of career dependency. That combination is exactly why these kinds of cases become so emotionally complicated in courtrooms. The alleged abuse is being tied directly to employment power and economic survival. She's describing a situation where every professional consequence allegedly became connected to whether she complied with the defendant's expectations. And then comes one of the strongest moments in her statement. Realizing there was an unspoken condition attached to "You'll always have your job no matter what." That line completely reframes earlier comments and transforms them from reassurance into something she now interprets as coercive control. This is also the point where viewers should understand why probation recommendations and restitution discussions later become such a major issue in this hearing. The alleged impact being described here goes beyond a single incident. She's claiming long-term psychological, financial, and professional damage. Do you think courts should treat workplace abuse allegations differently when employment power and financial dependence are involved? That question sits right at the center of what this courtroom is now trying to untangle.
It took me 4 years of abuse to realize that there was an end to that sentence that he never spoke out loud. You'll always have your job no matter what, unless you tell anyone what I'm doing to you. I sat in my office the day he assaulted me, staring at my phone where I had typed 911. My finger hovered over that call button for what must have been 10 or 15 minutes. If I called, I knew my job was over. I knew I'd wake up the next day unemployed. I knew he would fire me for telling someone about his inability to keep his hands to himself. But the alternative was to keep letting him hurt me, and I couldn't take it anymore. I couldn't take one more day of the abuse. I would lose a month worth of wages after making that call. I would spend thousands in therapy trying to make sense of what he had done. I would worry about paying rent. I would worry about feeding myself, about keeping a roof over my head. And then I would begin to worry that he would harm me further. In October, after the 911 call and Jason's arrest, he began to threaten me. He left a handwritten threat in my mailbox telling me to do the right thing in the middle of an impending trial. And I do say leaves because there was no forwarding address on that letter. Someone had to come drop it off at my house. And can you guess who was the only person at work who knew where I lived? When I didn't do exactly what Jason said, he started to show up at my house unannounced. He drove by my home and parked in front of my apartment dozens of times in an effort to make me feel unsafe, to make me feel like I had no other choice but to drop the charges against him if I wanted this to stop. Do you see a pattern? Jason has a back entrance from his house to his rental apartment, meaning he would not have to see me or be near my house at all if he wanted to check on his rental unit. Yet I continue to see him drive and park down my street. Any way imaginable that he could try to make me feel afraid is what I've had to live through and deal with since I called the police. When I didn't drop the charges, he started emailing me when there was a no contact order. And in every email, there was a threat. And every threat was sent from a fake name, from an email he and I set up for the sole purpose of setting up technology on the work site. I know this because I worked for him for 6 years. If Jason had actually wanted to message me something pertaining to work, he could have emailed me from his Jason @ handle as he had done for the past 6 years. But instead, he sends me back intellectual property that he stole from me from a fake name, minus anything I worked on for him, leaving me bereft for my own portfolio moving forward. And then tells me, I hope you got what you needed and we're in the clear, weeks before we're about to appear in court together.
The courtroom is now hearing allegations that extend far beyond the original abuse claims and into alleged post-arrest intimidation, harassment, and continued psychological pressure. What makes this especially significant is that the victim is not describing random contact she's describing, contact she believes was intentional, strategic, and designed to make her feel unsafe even after law enforcement became involved. The handwritten note, the alleged drive-bys near her apartment, the emails from fake accounts, and the references to work-related intellectual property all create a narrative that prosecutors and probation officials are clearly taking seriously. And notice something important here. Judge Simpson starts becoming visibly concerned once the discussion moves into possible ongoing contact during the pendency of the case. Judges take no-contact orders extremely seriously because violating them can completely change sentencing recommendations, probation conditions, and credibility assessments. The court is also beginning to realize there may be additional information floating between different police departments and agencies that has not yet been fully organized inside the official court file. That is dangerous territory procedurally because incomplete information can delay sentencing, trigger additional investigations, or reopen discussions about supervision and restitution. The hearing started as a sentencing discussion, but now it feels like the court is uncovering pieces of a much larger conflict in real time.
Jason J. Stevens, I am not afraid of you. Your threats do not work. It took me 6 months of intensive therapy to realize how badly he was abusing me. I entered the relationship with him consensually, but the abuse I endured was not consensual. The most disheartening part of this whole ordeal is being an up-and-coming young woman in a predominantly male profession and experiencing betrayal, mistrust, and abuse by someone I considered a mentor and with whom I looked up to. Jason could have made a difference in this world for not only young women like me, but young women like his daughter by holding his company to a higher standard than the one he created. And yet I am standing here today to hold him accountable for the actions he has done because he has chosen to do the opposite. I suggest battery intervention for Jason's probation. Jason chose to create a toxic workplace that is unsafe for any woman who steps foot on his job site. He created a world where women fail the moment they come to work. And if I have anything to say about that, that stops today.
Ma'am, I just want to clarify something. Thank you for that. Are you indicating that I think I'm aware of some of them, but that there was contact or alleged contact while this matter was
Yes,
at what points? Because
every month.
as I was listening to you, I don't think I have all of that, and I don't know that that's been taken into account with sentencing. Before you answer, Ms. Valera,
Yes, I don't have anything, Judge, so I don't.
Your Honor,
Oh.
we did raise the issue of the note on the document which was delivered by the defendant at the trial date, but the additional information with the additional context, we did not.
no, okay.
I had
So
a,
that's what I'm a touch bit concerned about, that I don't have everything in front of me.
Now Judge Simpson is hitting the brakes, and this is exactly what a careful judge should do when new allegations surface inside a sentencing hearing. He is not ignoring the victim's statement, but he is also not instantly treating every new detail as proven fact without records, reports, and proper notice. That matters because sentencing has to be based on reliable information. The victim has just described alleged contact, threats, and harassment that may not all be fully documented in the court file. Judge Simpson's concern is clear. If this conduct happened, it could seriously affect sentencing, probation terms, restitution, and the overall structure of accountability. But if the court does not have the documents, emails, police reports, or agency records in front of it, then moving forward too quickly could create a procedural problem. This is where the courtroom drama becomes legal precision. The judge is basically saying, this is serious, but the record has to catch up before the court can act on it.
I realize what you said in terms of where they were sent from, how you recognize them, whatever, but you still have those?
Oh, yeah. Yeah, I had a whole FOIA document that I had forwarded, I think, to Christine at one point.
Okay. So, all right. I think I want those.
Okay.
I want certainly Miss Polera to have those.
I can certainly give those to you.
The other thing that I'm wondering, and it kind of gets beyond the court's province, I think. You don't have this. You don't have this. As I understand that there was a work relationship, but there was also an intimate relationship at some point. Were we aware of that? Because here's my concern, particularly given what's been requested. As I'm reading the recommendation from probation, I would think that this would need to more look like, or should look like, a DV sentencing as opposed to what it's charged as, an assault and battery sentencing. I'm not saying go back and try to charge them. I'm not saying any of that. I'm just saying in terms of the structure of the sentence, given at least what I'm hearing here, I think that may need to be examined, particularly in terms of.
And Your Honor, I also know that Ms. Morley is asking for restitution. In the recommendation for probation, I was asking for a restitution hearing to be set, given light of her statement to the court, and probation being unaware of continued contacts and her indicating that she has proof of those. probation would ask that the sentencing be adjourned, where I can reevaluate and look at everything, to provide the proper recommendation, for sentence, as well as maybe address restitution all in one.
This is a major turning point because probation is now asking for more time, and that tells you the original sentencing recommendation may no longer be enough. The victim's statement introduced claims of continued contact, possible threats, therapy costs, financial loss, and restitution concerns, and probation is openly saying they need to reevaluate everything. That is not a small request. Probation recommendations can shape jail time, treatment conditions, no contact orders, monitoring, and financial obligations. Judge Simpson also raised an important issue earlier. This may need to be structured more like a domestic violence style sentencing rather than a basic assault and battery sentencing. Because the facts being described involve an intimate relationship, alleged ongoing control, and alleged post-arrest contact. That changes the entire legal lens. The court is no longer just asking, what happened on one date? It is asking, what pattern exists, what risk remains, and what sentence actually protects the victim while addressing accountability.
Yeah, well, and that's what I was going to do that mainly because of the initial thing that was said regarding the contact, because I don't have that. And can't take that into account. I guess the other, okay. And I realize at this point, it's in essence an allegation. The contact has occurred how often?
It's every month since he was arrested. So between October and March, I would say. That was in January. Yeah.
So there was contact in March?
Yes. For the very end of February to March. I can't remember the exact date, but it would have been like the last week of February, March.
Hey, ma'am, let me just ask you, when this contact would occur, what did you do with that?
I sent it to the cop who was dealing with all of this originally.
Pardon?
I sent it to the cop who was handling this case originally, or I called 911. So it's all documented.
Oh, well, I get that, but so
You
you,
didn't get any notice from the officer in charge of this case whatsoever about any violations that were sent to them by the victim?
He had a separate, what is the word? I'm blanking on the word, for his arrest in March because of the stalking and harassment.
Now the courtroom gets even more complicated because the victim believes there was a warrant connected to stalking and harassment, but the court and attorneys are trying to clarify exactly what exists in the official system. This is where real courtroom hearings can get messy fast. A victim may have reported incidents to police, spoken with different departments, or received information from officers, while the court file may only show one formal bond violation or warrant. Judge Simpson has to separate what the victim experienced from what is officially filed, verified, and available for sentencing. That does not mean the victim is being dismissed. It means the court has to track every allegation through the proper channel before relying on it. And honestly, this is a strong retention moment because everyone is now trying to answer the same question. Did the system miss something important? Did reports sit in one department without reaching the prosecutor? Or were the incidents already folded into the existing bond violation?
No, not complaint. He had a warrant out for his arrest in March because of all of the stalking and harassment.
okay, hold on. There's a warrant, you said there was a warrant out for him?
Mm-hmm.
Out of where?
14A District Court.
Anything?
bench one issued March 4th, but I don't see why
March 4th on this case?
on this case.
On March 4th. I issued the warrant for failure to comply with bond conditions. Is that still active?
No, I show it's canceled. It was canceled March 27th. It looks like it date.
When he came back, and that was part of the violations that he admitted to, that I'm taking into account in sentencing. So I get that one. But
That's all I see.
that's all you see in our system. So ma'am, you're of the understanding that there was a warrant of a new charge?
No, that's the same one that I'm thinking of.
Okay, that came out of this?
Yeah.
Got it.
Yep.
Okay. So, but so all of what you relayed to me today in terms of these contacts, those were sent to Pittsfield Township Department of Public Safety?
Yes.
Okay.
Or Ann Arbor as well, because I live in Ann Arbor. And so there was like a jurisdiction issue and the cop said that he couldn't handle anything that was not in Pittsfield. So when he dropped the letter off at my house, that was Ann Arbor. So maybe that's the issue too.
So some of this is in Ann Arbor.
Yeah.
Some of it's in Pittsfield.
Yeah.
Okay, beautiful. All right. And the prosecutor doesn't. Okay. So we'll have to round that all up.
Judge Simpson is now trying to gather the scattered pieces, and you can hear why the adjournment becomes almost unavoidable. Some alleged conduct may have happened in Ann Arbor, some in Pittsfield, and the prosecutor is saying they do not appear to have received direct bond violation information from either department. That is a serious coordination problem. When multiple jurisdictions are involved, information can get fragmented very quickly. One police department may have one report, another agency may have another contact, the victim may have FOIA documents, probation may have a recommendation, and the court may only have part of the picture. For sentencing, that is a problem because the judge cannot responsibly build conditions around missing information. This is also where viewers should pay attention to how Judge Simpson handles it. He does not rush. He does not pretend the record is complete. He recognizes that if these additional contacts are real and documented, they could matter, but everybody needs the same information first.
Ms. Yermolenko, is there anything you wanted to say regarding the request for an adjournment regarding the?
I don't have a problem. We were not, it's additional contact allegations. We were aware of there were 2 email contacts in, I want to say January. That's what the warrant bond violation was for. We addressed it at the last.
Correct.
It was set aside. All those additional allegations I've never heard of previously, and I would like to see those police reports.
And I do also want to note for the record, I just ran through my email. I did not get anything directly from Ann Arbor or Pittsfield with regard to a bond violation. We did receive an email from Ms. Morley regarding the FOIA, the information she received from the FOIA. I also just checked our internal file system, and the only case for Mr. Stevens, which shows all of the warrants that have been submitted as well, is this case. There is nothing.
There's nothing. Okay.
So there has not been an additional warrant request from Ann Arbor or from Pittsfield with regard to this case.
Got it.
Or, I should say.
I spoke to the Pittsfield officer myself when we found out about the warrant. He did not mention any additional context, but once again, we were not aware of the additional context that would be mentioned.
Okay, right. Got it. Okay, and so that I'm also aware, and the claim for restitution is for It's general.
Yeah, she's asking for, to cover therapy.
Got it.
She did provide some, receipts. We were taking a look at those today. I don't think that I have everything. I think that she may be looking, for additional.
Got it. Okay, so May 8th probably not, it's gonna be too soon. Or, I mean, it's not too soon for me. I want everybody to be able to do the work. That's my concern. And Ms. Yarmolenko has risen and she probably isn't available. Of course not.
This line basically sums up the court's position. The hearing cannot be about speed if the record is incomplete. Judge Simpson is making it clear that the goal is not simply to get the case off the calendar. The goal is to make sure probation, the prosecutor, defense counsel, and the victim's documentation are all properly reviewed before sentencing moves forward. That is especially important because restitution is now part of the discussion. Restitution is not just a random number someone says in court. The court usually needs receipts, documentation, proof of loss, and a connection between the loss and the offense. Therapy costs, missed wages, safety-related expenses, and other claimed damages can become legally important, but they must be evaluated properly. The defense also has a right to review and challenge what is being requested. So even though delays can feel frustrating, this adjournment protects the integrity of the sentence. Judge Simpson is trying to avoid a rushed ruling that later becomes vulnerable because someone did not have the evidence.
But I have another problem with the 15th of the court.
Well, no, we don't do.
It's not gonna be enough time.
What about the 22nd? Your work? Okay, ma'am. So what I'm going to do is I will adjourn this to May 22nd, 2024 at 9 a.m.
I'm so sorry, but I thought it was gonna be enough.
Whoa. Now you're throwing things? Okay, yeah. You thought it was going to be in the afternoon.
I did, I am scheduled to be in Greenwood Heights this report all morning, that morning.
No way.
I'm available in the afternoon, just.
Is that one in the morning?
It is.
It is. But I will
also be gone that day. Is it possible?
oh, heck, I'm gonna get out of town too. So we'd have to go to the next.
June 12th at 9 a.m.
June 12th work for everybody?
With 10 a.m. work. I have a thing in front of the car at 9.
He'll wait. No.
Now we are in scheduling mode, but do not mistake that for the drama being over. The fact that everyone is trying to land on a new date means the court has already accepted that sentencing cannot responsibly happen today. And that is important. The victim came in ready to speak, probation had a recommendation, and the court had a path forward, but once new alleged contact, possible harassment, restitution questions, and agency documentation issues entered the record, everything changed. Judge Simpson is now giving the parties time to collect and review what should have been available before the final sentencing decision. This is exactly why victim impact statements can be so powerful in court. They do not just affect emotion. Sometimes they reveal missing facts that change the legal process itself. The big question now becomes whether the additional documents support the victim's claims and whether that changes the eventual sentence. Should a judge delay sentencing when new allegations surface at the last minute, even if it frustrates everyone in the courtroom?
Okay, no, go there. Let us know. Well, of course, you're just right up the. Yeah, that's famous last words. June 12th, 2024 at 9 a.m. Thank you, ma'am.
Thank you.
Thank you.
And that closes a hearing that started with one case about phone privileges and bond concerns, then shifted into a completely separate sentencing matter where the court discovered it may not have the full picture. In the first matter, Judge Simpson made the defendant's phone restrictions clear, set the forfeiture by wrongdoing hearing, adjourned the preliminary examination, and denied the bond reduction request. That ruling kept the bond in place after the prosecution raised serious concerns about alleged witness intimidation, jail calls, and the underlying allegations. In the second matter, Judge Simpson did not rush sentencing. After hearing the victim's statement and learning about alleged continued contact, possible threats, restitution issues, and missing documentation, he adjourned the sentencing to June 12, 2024 at 9 a.m. The key takeaway is simple. Courts move on evidence, records, and procedure, but victim statements can expose gaps that force the entire system to slow down. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.